Okay, I think we have everybody back that we were expecting back. As we noted before the break, we no longer have a quorum, so we can no longer do any voting. But I think the next couple of topics are more open discussion anyway, so that should be fine. So with that, we're back on the record. It is 12:51, and we're on agenda item 8 regarding income share agreements.
Wonderful, thank you. So very interested and excited for this discussion today. I know income sharing agreements have been a topic of interest for the Bureau and many Bureau approved schools for several years. And of course, income share agreements are a financing arrangement through which students pay a percentage of their income, of their post-enrollment income, in lieu of paying tuition upfront. The Bureau's prior conversations and analyses have really highlighted the regulatory gray area in which ISAs exist because major regulators had not drafted rules specifically to address ISAs. We're putting this on the agenda today because that appears to be changing. In August, California's Department of Financial Protection and Innovation, or DFPI, entered into a consent order with Meritas, which is a New York-based ISA provider, and agreed to basically agreed that ISAs would be treated alike and reported as student loans. In September, the Consumer Financial Protection Bureau also took action against an ISA provider for basically falsely representing that its ISAs were not loan products and did not create debt. So these are notable moves in the regulatory space with respect to income share agreements. And we wanted to raise with this committee questions about how these types of shifts should inform the Bureau's own actions. Prior Bureau analyses have really looked at several different code sections related to total costs and looking at as a tuition model. But there are sections of the Private Postsecondary Education Act that do pertain, specifically to student loans. Article 12 of the Act in particular has several very specific provisions related to student loans. So we wanted to have a discussion here about how the Bureau might want to be responsive to the evolution of the field. So to kick us off, we actually have with us here today Adam Wright, who is with DFPI's Office of Financial Technology Innovation. And so he's here with us today to speak a little bit about DFPI's recent actions and also answer any questions from the committee. So I'll turn it over to Adam. Thank you for being here with us.
Sure, thanks. Yes, I am an attorney with the department. I'm with our innovation office, which is a new office that's intended to monitor and encourage growth of responsible, innovative financial products in California. Prior to my time in the innovation office for 8 years, I was with our enforcement group, where I dealt with lending and credit products, including most recently income share agreements. The department that I work for, the DFPI, has an overlapping mission with the Bureau. We're both looking to protect students. We license, examine, and supervise person-supervised credit or lend to students. And we also license, examine, and supervise persons who service that credit made. Servicers, just in case you don't know, are companies that take payments on loans, mail account statements, handle customer service, etc. And the goal of our work in this area is really to protect student borrowers, I think, which makes our agencies kind of natural allies in this space. We employ financial examiners and other professionals who are expert in ensuring that credit providers and servicers comply with all state and applicable federal law. We understand that these products can be complex and that the laws that apply to them are complex, and we're really ready to help the Bureau and partner with the Bureau in any way to help the Bureau approach some of these new modern financial products like income share agreements. So I think the issue memo that was in the meeting materials really hit the nail on the head and presented two of the more recent actions. The one from my department, which found that that income share agreements are student loans for purposes of our Servicing Act. And Debbie also mentioned the CFPB action. Those are two of the recent actions, but there's more. I think there's actually been 4 states over the last several months that have indicated that they are going to be treating income share agreements as credit. And Washington released interim regulatory guidance late last year. We've seen Illinois with their new law find that income share agreements are loans, and they actually provided rules for how the terms of income share agreements and the financing thereunder should be disclosed to borrowers. Colorado provided some similar notice, and Iowa has also provided similar notice that they believe that ISAs are regulated credit products in their state. So we really believe there's a drumbeat of activity that show that ISAs are going to be regulated as credit by state and federal regulators. That's really the wave that we see. And there's clear benefits of this trend. We believe that treating ISAs as credit ensures that all student borrowers receive the full suite of protections that are available to them, and it makes sure that they're subject to the additional oversight and supervision that credit products receive. The label or the title of the product used to finance education shouldn't dictate a borrower's protections. That's our belief, and that's what we're striving to achieve. So I also understand that in the wake of these actions, right, there's been many of them, 6 of them that we've mentioned already, that ISA servicers and issuers are assessing how they're going to be able to make and service ISAs in compliance with state and federal laws. My department has already received requests from issuers and servicers seeking guidance on how to do this. So we really feel like this is coming. So, as I said at the outset, my department sees the Bureau as a partner in protecting students, and we welcome collaboration with the Bureau in carrying out both of our missions. We think the coordination among all of the interested regulators is key from the state and the federal level to maximizing student and borrower protection. And to start, we would encourage, any students to file complaints with us relating to their financing products, including income share agreements. And we would welcome the Bureau referring complaints that they receive to us as well if it relates to financing products, including income share agreements. And we're happy to collaborate on, one of the topics mentioned in the issue memorandum, which is important, something that our agency is thinking about, is how are we going to examine income share agreements for compliance with TILA, the Truth in Lending Act. We're happy to coordinate and partner with that with the Bureau and leading that forward and making sure that we get it right at the state and the federal level. And so with that, happy to take any questions or discuss anything more of the department's actions in this space or more generally the topic.
Hi, this
Thanks,
is
Adam.
Margaret.
Oh, Margaret, go ahead.
Sorry, go ahead.
So thank you, Adam, for being here. Really appreciate it. And I think I have been eyeball deep in ISAs for the past 5 years. And I honestly, everybody that I've spoken to, clients, because I have clients both in the school space and the ed tech space who, touch on this, that they're all happy just to know what they're supposed to be doing. So I appreciate your willingness to work with them. I've actually had a couple of my clients that are ISA servicers or originators who have asked me if there's someone at Dfpi they should talk to about what to do. Now I know you're
Sure.
expect a lot of phone calls, but we appreciate the guidance. So I will say that from the beginning of the Bureau's sort of having a published memo on this topic, that I think has been the push and pull on this, which is highlighted in Deb's memo, is whether or not this is varying tuition structure or this is a financing tool. And I've always argued it is a financing tool and it should be treated that way. And that was not the Bureau's interpretation. And so we've constantly had some sort of challenges on, so what does work? What will meet the requirements of the regs? So in my opinion, I think these movements with the financial sector oversight that the DFPI has and CFPB is actually really helpful because it establishes that what the expectation is for how these products will be used. And I'm hopeful that the Bureau will now shift away from this concept of an ISA as a tuition arrangement, and instead it is a financing tool like a loan. And if there are issues with that, then that would be something that would go through the DFPI as opposed to the Bureau, who, they're not financial experts. And I think that having the ability to work with you to make sure that the tools that schools and ISA providers want to provide as options to students meet your expectations, that the Bureau isn't put in the position of trying to make a call about whether or not a financial instrument complies with financial regulations and statutes. So I will leave it at that. Margaret, I know you were ready to comment as well, so I'll defer to you.
Sure. One question to start with. In the ISAs that you have seen, Adam, are those agreements between the school and the student, or the school, the student, and the lender, or between the student and the lender, or all of the above?
So I want to make sure I distinguish between what I've personally seen and what the department has seen. And so I can just mention that personally, I've seen both flavors of school and student. and third-party financer and student. One thing I want to make clear is that our action that we did personally as a department was against a servicer, and so the servicer wasn't necessarily a counterparty to a student. But those are what I've seen personally. But we have many folks here who are looking at the issue and who probably seen more stuff than I have, and so would be happy to get back with you all to talk more about what we've seen, if that makes sense.
Sure. And a question, and this may be out of your bailiwick because you're dealing with servicers, but as I understand it, the CFPB recognized as I had pointed out when we talked about this before, that these documents need to provide truth in lending disclosures and comply with truth in lending. One thing they didn't explicitly address is that it seems to me these also are subject to the FTC hold. And I wondered if you had looked at that at all in connection with what you've been doing. So I realize you're dealing with servicers, not the actual lender.
Oh, and to be clear, I mean, it's something we're considering too on the issuer side as well, right? It's just we haven't done anything publicly yet. And so, yes, that is something we're thinking about as we're reviewing them. And so I think you're going to see more to come from us on those topics in the future.
Right. And then I have some comments to make, but I'll save those until everybody else has a chance to ask whatever questions they have to ask of you.
Other questions for Adam? I have another one while we wait to see if anyone else does. Is the DFPI considering regulations to incorporate ISAs into the Servicing Act and presumably the Lending Licensing Act?
Yeah, and so one of the things, so whenever we did our servicer action back in August, we released a press release that also mentioned that we're going to pursue and propose specific regulations applying for servicers and issuers, and so we're working on that. And so I don't want to talk anything more about what that will entail, but that's something that's going to come from us soon.
Thank you. Margaret, I think you can go again. No one else has jumped in.
A couple of things. First of all, as to the comment about this should be financial regulators dealing with this rather than the Bureau, I think the Bureau clearly has it in its bailiwick, although it may not be its primary focus or its particular area of expertise. I see no reason why the Bureau shouldn't be looking at this and cooperating and coordinating with other agencies such as the Dfpi, the CFPB, the attorneys general or the attorney general in California, or district attorneys in California who may be interested in the topic. And that's, I raised the issue of the holder rule, the holder due course rule, their claims and defenses rule, holder rule, which was set up, I think, in the 70s to protect people who get a product or a service and then sign on to financing for it. And if the product or service turns out to be useless, and they say, wait, I'm not going to pay for this because it's not what you represented, or it doesn't work or whatever, the lender would nevertheless go ahead and say, well, tough cookies, that's your problem with the seller, not with me, and go ahead and try to collect. And the holder rule was put in place to try to prevent them from making that, from in essence, recognizing that there is a linkage and that the consumer should not be on the hook to pay the creditor who was involved in the arrangement of the loan to begin with from the seller and what they provided. And in the California statute, when the school is a party to financing, they are required to provide a notice of this consumer's right to their protection, in essence, of the same as the holder rule. So I think that's something that the Bureau definitely needs to be checking on these ISAs for, to be sure they include that required statement. Apart from that, and the FTC holder rule itself is a little broader even, so that it would require that notice. There's two different forms of it, whether the lender is a party to the original contract or not. And so clearly that's something that, to comply with consumer laws, to be there. If the school doesn't that, even though that is in an unfair business practice and also in misrepresentation. That also would be under the Bureau's bailiwick. I'm not saying that the Bureau necessarily needs to have a whole section set up on enforcing these things, but definitely needs to be involved in working with other agencies and ensuring that these provisions are in fact carried out. And I would just ask, I think, Adam, that that there is a very good look at the holder rule and how it applies. I think that there's several issues here. One truth in lending, one is the holder rule, extremely important. And the final thing I would say is when this has come up before, my understanding has been that the Bureau was not approving schools engaging in these. And so I have read recently that in fact there are California schools doing this. And I hope that the Bureau, one of the first things it does would be to put these schools on notice that if they haven't complied with the truth in lending, if they haven't complied with the holder rule, the schools that are using those are in violation, and that needs to be corrected ASAP. And I would hope that the agencies would be able to cooperate in looking at these issues. These are extremely important.
And I lost connection for a second there. Can you hear me now? I'm sorry.
Yeah, we
So
can hear you, Adam. You did drop for a second, looked like.
yeah, and so sorry about that. And so definitely, if it helps, I mean, one thing I can address, I can't speak about what we intend with future rulemaking, but one thing I did want to point out is that as part of the consent order that we did with the one ISA servicer that we've done, we did include a provision that made sure that the servicer would not be able to service ISAs that another regulator like the Bureau or ourselves determined was void and unenforceable. And so it's something that we're thinking about, additional protections that can be included. For example, our department recently got some more broad authority to be able to protect consumers under the California Consumer Financial Protection Law, which gives us more tools than we traditionally had as a licensing agency. And so I would expect that that's going to be something that we're going to consider as well in making sure that we protect students under these products.
Just in response to Adam, one thing I was noticing in your consent order, just for future reference, that paragraph you're referring to, which is, I guess, Q3, if a contract has been determined or declared unenforceable or void by any of these agencies, and I would just hope in future agreements of this sort. I realize this is kind of the first one out of the box, but that language be a little broader, because the CFPB has clearly come down on it's in violation unless it complies with TILA. And so while they haven't specifically determined on this particular contract or this particular company, that's a clear indication that a regulatory agency that has authority over them has determined that if it doesn't have TILA disclosures, it's not in compliance. So just maybe for future references, you go forward, if there are more of these, to maybe broaden that language a little bit, so it's clear that if somebody's already weighed in on it, even if it's a different contract, that's something that's not enforceable if it doesn't comply with those requirements.
That's great input. Thank you. We're going to make sure we consider that. So thanks for that.
And the counterpoint to Margaret's point is that TILA is structured in a way that is the entire disclosure process can still work. The participation, the final disclosure, all the sort of process can work. The problem is that the way that TILA is written for disclosing how the cost of financing, it doesn't quite fit. And I think that's if you look at a lot of the ISA providers and servicers, they have a TILA adjacent process that has all the disclosures and the time and the 3 days to cancel and all of that. But what you sort of think of as the standard TILA form that has the amount being financed, and then the APR, and then and then what it looks like over the course of the whole thing. There is no interest rate on an income share agreement. So I think what a lot of folks have done is tried to modify that form so that it still got the same information out, but it doesn't exactly fit into TILA, which I think is one of the things that we're hoping will come through regulation, is how how it would be modified to still meet the requirements of transparency and disclosure to students, but not be confusing to students with the, the way the TILA standard form is laid out. So I think, to your point, Margaret, before this past summer, we didn't have a CFPB action or a Dfpi action that said, hey, we think these are loans and this is how they need to be treated. So prior to that point, I think everybody was just doing the best they could and trying to figure out what made the most sense for students and that they were getting the right kind of information. But hopefully, as we go forward, this becomes more structured, they'll actually be able to say, okay, well, this is what the form for an ISA needs to look like and include, and everything else can still be the same. The process, the timing, all of that still works. It's just I think the form was part of the challenge. So, Adam, that would be my 2 cents on Margaret's 5 cents.
And 1 more cent. Under open-ended credit, there is not a fixed payment, etc. But like under the ISA, there is a maximum. And you, with an open-ended credit contract under TILA, what you do is you have to disclose as to whatever the maximum is. And if it turns out to be less, that's fine. I think ISAs are the same way. While it may vary, you certainly can disclose a maximum. And I think that any company that was offering ISAs and wasn't giving TILA disclosures was well on notice that if they had taken a look at TILA, they would be well on notice that it quite likely would apply and that they were taking a calculated risk that they would be okay. So, I don't think that that's sufficient that they were, sort of coming up with what they were doing, even knowing that probably TILA applied and they weren't including that. But in any event, hopefully going forward, we'll have now that we've had some definitive word on it from a couple of sources, a lot more compliance.
I had just one comment specifically relative to the Bureau's memo and some of the questions posed at the end there. I think it's a positive that we now have a category definition. Agree totally, Kate, that at least now there's a path, and so we schools and ISA providers would understand what bucket they're in, right? That's the positive. The negative, though, is there is a bucket, and the bucket doesn't work for the ISAs, right? Like, so it actually creates now some concerns and problems, specifically in terms with Article 12 and trying to shoehorn an ISA into the current Bureau language and regulation around student loan instruments, I think is a bad idea and creates risk for schools and uncertainty for the Bureau, basically. And so the question is posed in a couple different ways in the internal memo as to whether new regulations or additional definitions need to be clarified in order to fit ISAs in that student financing bucket. And I think the answer is almost certainly yes, that we have a direction now and some clarity in terms of how to approach the instruments, but the current language is insufficient to do that effectively.
As to the question about how this impacts STRIF, I frankly have not had enough time to really look at that in detail, but I will be trying to look at that in more detail. I come up with some thoughts on that. I'll try to provide it.
And the STRIF question has come up before too, Margaret. I think we talked about it 3 years ago, whenever the memo put out, the Bureau put out the original memo. And I think that what a lot of institutions and ISA providers were trying to do was, like, for purposes of reporting to STRIF, they would report the total amount of the program tuition, and then the way that it would be dealt with if the school closed would be just like it would be if a student had a loan. So the point at which the student might be filing for a STRIF assistance, it would be based on what the student had paid up to that point, right? Because that is like a loan. The student might have made 5 payments or they might have paid it off. So you don't really know the economic loss until the student files and you see where the student is. But it is a tough one because of but I think that that's true of all of the financing products that we have, because if STRIF is really built around what's the cost of the program, then the cost of the program, just generally speaking, doesn't include federal loan interest. It doesn't include any of that. that's all sort of dealt with on the back end if it comes up. So that does create some challenges, I'm sure, for the STRIF folks to manage. So I do think that's something we need to at least consider how it gets worked in, and also refund policy, because generally speaking, with an ISA, the student doesn't pay anything. So if they withdraw, what are you refunding? The student hasn't paid anything yet. Are you just reducing the amount they owe under the income share agreement? So there's a lot of those things, and I think to Joseph's point, that are a little unclear. And the more I think we get from DFPI on what is appropriate from a financing perspective, the easier it will be on the Bureau side to figure out how it fits. All right, does anybody else have any other thoughts or questions? I will say that I'm excited that we're moving on this one, because this has been a tough on a lot of schools that had to completely change how they were operating their financing for students with the Bureau's position. And I'm sure that there will be many that will be excited to figure out how to be compliant and start offering this as an option again. Adam, do you know if there's, sort of beyond ISAs as sort of its own very specific, product, but a lot of what institutions have done is tried to come up with other sort of income-based payment models, not necessarily an ISA where it's, you're paying a percentage up to a cap, but instead doing something that's like here you're taking out a $15,000 retail installment contract, and you're going to pay us based on your income until you've paid it off. Is that it's still a retail installment contract, but it has an income-based payment model? Is that something that the DFPI is also kind of looking at in conjunction with this, or would that still sort of be separated and under the RISA requirements instead of the ISA requirements?
It's something we're aware of. So licensed servicers who are servicing products like that under our student loan servicing law, and so I'm not sure. I don't think there has been as much of a movement not to have those be considered credit as we've had in other spaces, and so, but definitely something we're thinking about as we try to provide more guidance on this to make it easier for folks to know what they need to do.
Debbie, could you have Richie send Adam's contact information, so if we wanted to send more information to him, we could do that?
Absolutely, provided that Adam is fully comfortable with that.
No, please. I mean, one of the things we wanted to make sure that we conveyed is that, this is an undertaking that many agencies are considering, and so the hope is that we can stay in sync and help each other out as we go through it. And so that's why we wanted to be here today and speak with you all. That we're ready to help and ready to support.
Thank you so much again, Adam, for being here today. It sounds like this is definitely conversation number one, or at least number one in the 2021-22 realm. I know there were a lot of conversations prior to this, but certainly we will, we're going to be working in close coordination with DFPI, looking to them for guidance in their regulations in terms of some of these definitional pieces, and of course, in partnership with them in terms of investigations and enforcement more broadly. So just really, really happy that Adam is here and to keep continuing this conversation.
And thanks for having us.
I'm sorry, just one last thing. And the thing I mentioned about the Bureau disclosure requirement on the holder, which is, I don't remember the section number now, but 94916. If that's not included in the agreement, and some of these I understand have been represented as, quote, not loans and not credit, not financing, whatever. If that language is not included, then the lender may argue when the student attempts to recoup from the lender, hey, I was not on notice of that and therefore have no responsibility. So it is critical that the Bureau make sure that any such contracts where the school is involved do start have that notice in ASAP, and maybe even notify lenders that even if the notice wasn't in the contract, that you're putting them on notice that they are subject, and the school should be on notice that they can be subject to prosecution or violation of the consumer laws as well as the Bureau laws for not disclosing that as an unfair business practice. So something to take a look at as soon as possible.
All right. Does anybody else have any questions for Adam before we close out this agenda item? Adam, thank you so much for being here. And I'm sure you're going to be getting a lot of calls and emails with questions about this. So with that, I will ask the moderator to, oh, Deb, did you need something?
No, I was just going to suggest you might want to stick around for public comment, just in case there's anything.
Yes, good call.
Fine.
Moderator, can we open the floor to public comment on item 8, please?
Thank you, Madam Chair. The Q&A panel is available, and we are displaying instructions. If any member of the public would like to comment on this agenda item, please type that you would like to make a comment and submit it using the field in the lower right-hand corner of your screen. We have a couple of people that have indicated they would like to make comments. The first is Claire Torchiana. So Claire, I'll let you know when you can unmute yourself. All right, so Claire, you should be able to unmute yourself. There you go, and you'll have 3 minutes.
Hear me?
Yes.
Oh, hi. Hi, Chief Cochran and members of the advisory committee. Thank you for the opportunity to speak to you today about key concerns related to the use of ISAs at private proprietary institutions in California. My name is Claire Torchiana, and I'm counsel at the Student Borrower Protection Center. So for years, California has been at the forefront of the fight to protect student loan borrowers, and the Bureau's attention today to the topic of ISAs, I think, is a testament to this. As you know, ISAs are a form of private student loan offered by schools and sometimes third parties for students to pay for their education. They've become popularized at tech boot camps in the Bay Area. The basic idea is that in exchange for tuition financing, students sign away the right to a fixed percentage of their future income. Often schools will use ISAs as a deceptive marketing scheme, claiming to students that their incentives are aligned, when in fact the school's goal is often to sign up as many students as possible for ISAs. The promised tech jobs often don't materialize, but the ISAs usually kick in at incomes that are far below the averages for a tech salary. Many schools that issue ISAs have sought to evade federal and state regulations, notably by claiming that what they offer is not credit under relevant laws. Thankfully, state and federal regulators aren't falling for it, and neither should the BPPE. The CFPB recently affirmed in action, as you know, that ISAs are private educational loans and credit under federal law, and the Dfpi, as we just talked about, issued an order finding that companies servicing ISAs are serving private student loans. The Bureau has a crucial role to play. We offer a few common sense approaches for the Bureau's consideration. For one, we want to note that, contrary to many of these schools' claims, a school that issues ISAs doesn't exist in a different category than other for-profit schools. Schools that offer ISAs are offering them as an alternative financing mechanism for students who can't pay upfront tuition. So many of the Bureau's current rules can be applied to schools that issue ISAs just by considering the upfront tuition cost. For instance, rules around enrollment disclosures, strict fund requirements, and refund policies. Second, we encourage the Bureau to clarify that these bootcamp programs must register or receive approval to operate to issue ISAs. The Bureau should make it clear that ISAs issued by unapproved schools are unenforceable under California Education Code Section 94917, and that TILA disclosures and holder notice is required under the Bureau's laws. Third, there are some areas where the Bureau's approach to schools that issue ISAs could be clarified, either through rulemaking or issuing public memoranda.
30 seconds.
Regarding refund policies for students who withdraw or schools that close. Fourth, we encourage the Bureau to coordinate closely with the Dfpi, and we're happy to hear that that's happening. And then lastly, the BPPE should collect data on how schools are issuing ISAs. Thank you so much for your consideration.
All right, the next request for comment is from Jordan Wicker. Jordan, I'll let you know when you can unmute yourself. All right, Jordan, you should be able to unmute yourself. There you go.
Thank you for the opportunity to comment. My name is Jordan Wicker. I'm the Executive Director of the Invest in Student Advancement Alliance. The ISA Alliance is a nonprofit membership organization made up of education ISA stakeholders representing the full continuum of the ISA community. The ISA Alliance represents a significant portion of the current education ISA originations to date. The ISA Alliance believes in the positive potential of ISA adoption and application to improve educational attainment with student outcomes, equitable access, and improved affordability for education and workforce training. The ISA Alliance is dedicated to the promotion of effective ISA regulation, which will allow for an accountable community of ISA-enabled education and workforce training providers. An education ISA is predicated on the concept of incentive alignment around education outcomes between an institution and its students. The education providers represented by the Alliance all have stated tuition. With an ISA, a student receives education and training in exchange for a promise to pay a known fixed percentage of his or her future income for a fixed number of payments. ISAs come with unique protections for student downside risk, including minimum income thresholds under which a former student owes nothing unless his or her income exceeds that threshold. ISAs shift the risk of an uncertain future away from students and onto schools. In contrast to loans, an ISA obligation does not guarantee any payment to the owner of the ISA. ISA obligations can be fulfilled in one of three ways. The first, the student makes the fixed number of payments. Second, the student excels and reaches the predetermined payment cap. Or three, the total deferment period is reached. The Alliance appreciates the BPP's understanding that ISAs currently operate in a legal and regulatory uncertainty. The Dfpi order with Meritas is clear that it applies only under the SLSA, and no guidance exists under California law that ISAs are loans for any other purpose. BPP should rely on the Dfpi for defining which consumer finance laws apply. However, the Alliance believes that innovation in education finance can be matched by thoughtful adaptation for student protection laws. The BPPE should clarify how ISA-enabled schools can comply with the legal questions raised in the previous memo. ISA Alliance member education providers all provide disclosure of a set tuition amount compliant with the disclosure requirements for total charges for both the enrollment agreement and the catalog. They also provide refund methodologies that result in a proportional reduction in the ISA obligation.
30
The
seconds.
ISA Alliance looks forward to continuing to work with the BPPE and the Dfpi to create the necessary regulatory framework so that education providers can continue to offer ISAs that align school incentives, creating accountability for student outcomes. Thank you very much.
All right, and the next request for comment is from Angela Perry. Angela, you can unmute yourself now.
Angela Perry with TICAS. I just wanted to say on this topic, ISAs are an incredibly complicated issue, but one where students are potentially put at risk, and particularly the risk of inequitable harm to students that have been historically disadvantaged. And so we are very glad to see that the Bureau is continuing to monitor this. We were pleased to see the CFPB and DFPI actions and announcements to protect students on this issue. And we would echo that the Bureau really does play an important role in the oversight of ISAs. But we are really gratified to see that the Bureau and DFPI are collaborating to work together to find streamlined and appropriate responses to this. If there are statutory changes that are needed, which I think the memo indicates that there are definitely questions there that will be addressed hopefully in sunset or otherwise. TICAS and others I know are definitely, other student advocates are very interested in working on this issue and definitely support that. So if there are opportunities for us to be helpful, we definitely support that. And we hope that the partnership between the Bureau and DFPI will continue ongoing in the future and continue to be strengthened. We're very excited about all of the work the DFPI is doing, and definitely think that collaboration between the Bureau and DFPI is going to be a great thing for the state of California. So with that, thank you again for these updates, and look forward to working on any needed statutory changes to make sure that students are protected in this area. Thank you.
All right, this is the moderator, and that is the last request for public comment. Shall we close the Q&A panel?
Yes, thank you.
You're welcome.
All right. Well, thanks everybody. Great discussion, and obviously more to come on this. And thanks again, Adam, for joining us today. We really appreciate it.
Of course, thanks.
That takes us to agenda item 9, continued discussion on Senate Bill 118 regarding criminal history and admissions decisions.
So I will kick us off on this one as well. So, Senate Bill 118, captured in 2020, it was a topic of our conversation at our last meeting in August. And particularly the requirement that colleges no longer consider criminal history as part of the admissions process. So again, as a reminder, the relevant code sections aren't actually in the Private Post-Secondary Education Act, but we do know, of course, that this is an important topic for both the schools that the Bureau oversees as well as the California students that we are hoping to protect. So, this obviously is a topic that's relevant for conversation as a group. At our last meeting, we presented a memo outlining some of the broad issues at play, including discussing how this is really part of a broader criminal justice reform movement. And how, for a variety of reasons, pre-screening applicants in the way that colleges had become accustomed to may neither be viable to the extent it was previously or even warranted given other changes in licensing entities. I know there was still interested in having more discussion on the topic, and I recently had the opportunity to hear Advisory Committee member Joseph Holt share some of the ways in which his colleges are adapting to be in compliance with the law. And I found it so impressive, I asked him on the spot if he would be willing to present to the committee some of those actions and changes that they've made. So I'll turn it over to Joseph.
Very good. Thanks, Debbie. And to be clear, this is thoughts and ideas we've developed in our colleges, but in close collaboration with many other school systems in California and our colleagues in other states as well, to best serve students in this changing environment. And I wanted to thank the Bureau again for the diligent follow-up on the issue and the publishing of the previous memo, which was helpful to grant some direction in that regard. So by way of sort of early best practices, if you will, in consensus with some multiple school groups in California, really center around sort of 3 topics: notice, advising, individual advising, and then the application of bright line standards. In regards to notice, having a clear communication to all students during the admissions process that criminal history or criminal convictions may have a negative impact on the student's ability to complete the educational program and or secure in-field employment after graduation. So this would fall under the broad category of disclosures, having written and even verbal communication with students, letting them know that we're not asking about that and we're not requiring you to fill out a form that says whether you have a criminal history, but be aware that if you do and we don't talk about it, that could have a negative impact either on your educational experience, which I'll refer to more shortly, or certainly in your ability to obtain employment following graduation, which is something that the student would need to take into consideration. The second element there is the next step would be advising and encouraging. Well, our schools are applying this during new student orientation primarily. So it's SB 118 is very clear, and the related law, that you can't use any criminal history information as an admissions decision during the admissions process. After students have enrolled, we've made an acceptance decision in our meetings with the student, especially in new student orientation. We again bring up the notice that was brought up during the admissions process and encouraging individuals to opt in to advising with an academic dean on the campus or a program director in their chosen field of study. Specifically to have a one-on-one conversation, a real conversation about how, if they have criminal convictions that they're concerned about or have questions about, they can look at their personal situation. And so we encourage and solicit them. We don't require them to fill out a form again necessarily, but we encourage them to self-disclose that and in a private setting with again, either the academic dean or program director. We've provided those academic professionals with a sort of a rubric of the types and kind of convictions, that considers severity, recency, that helps them as they dialogue with the student to have kind of a talk track to say this is likely to be a really big problem, or this is something you should be aware of, but maybe and keep in mind, but it probably is unlikely to be a high risk area or may not be a high risk area to the degree we're able, based on our placement experience in terms of placing graduates in that specific field. And then also in regards specifically to clinical extern rotations, which is something that is of critical importance, and it's one of the areas, going to our third point on bright line standards, that we, and I know other schools have been the most aggressive, is if we have clear information or get clear information that we're not going to be able to complete the educational experience for the student because clinical affiliation agreements specifically require criminal background checks. So interestingly, those are not covered under SB 118. So when we have an affiliation agreement with an education or with a medical provider, for example, and the students prior to being placed on extern have to complete a criminal background check or clear a criminal background check, and that course, extern course, is required for graduation. That's an area where we draw a bright line standard for, and there's a couple of ways of flexing that. One is under the use of the professional degree designation. So nurses, for example, we've determined a professional degree, and that aligns with the fact that our clinical externship agreements require background checks. And so the whole area we referred earlier to kind of gray areas. There are some areas that are obviously very subjective, and for the student to make a decision, an informed decision. This is one where we're being fairly aggressive. If we're concerned that we're not going to be able to complete your educational requirements on the basis of what you've disclosed to us in terms of your criminal history, then we will cancel an enrollment, and so we are somewhere on the spectrum of advising a student that they should proceed with extreme caution up to canceling an enrollment agreement because we're not confident that we can complete that student's educational experience. We do conduct background checks for professional degree designated programs, as I mentioned, and our key North Star on that is the ability to complete coursework required for graduation.
Thanks, Joseph. That was really great. And I will echo the importance of disclosing this to students upfront, because I think before was sort of just built into the process that students who would be challenged to complete or sort of weeded out before you ever got to an enrollment agreement. So this process, I think, that you described, it is getting to the spirit of the intent of this, which is someone's criminal background should not be the deciding factor, but it may have an impact. And so students, with good, strong disclosures can make those informed decisions. So I think that your process makes complete sense and is similar to what I've advised my client schools to do as well. So does anybody else have thoughts or input on how 118 is working?
Oh, if all the schools only operated as Joseph does. This is Margaret. And that makes me wonder, I mean, it seems like a very sensible, reasonable process. And it makes me wonder whether we should be looking at whether there are statutory or regulatory changes that we should do that would require part of this process or part of this process, so that even though the thing, of course, I'm concerned about from the other angle of it, or the other side of it, is people getting enrolled by schools that are not so upfront and reasonable in programs where they will never be able to get a job, but they had a quote disclosure which was tucked in among a stack of papers, and the school is now feels off the hook. And so I'm just wondering if we shouldn't be looking at changes in regulation or statute that would provide some of these steps as requirements.
And Margaret, I think one of the interesting dichotomies of this is that I think this is a situation where schools are more than happy to be very upfront with the disclosures, because if a student isn't successful, especially for an accredited institution, that means you have a withdrawal. That's a student that didn't complete. That's a student who doesn't get a job. And all of that is stuff that the school is accountable to. So I know, at least for my clients, that they're very concerned about students not, starting a program, spending money, and then not being able to do clinicals or get a job afterwards, because it affects both the school and the student. So I think that there's an incentive for the school to be much more upfront about this, because the student won't be a graduate, and that doesn't look good for the school either. So, but I think that it's and that raised a question, actually. Is this something that can be part of a regulatory package for the Bureau when the statute is not within the Private Post-Secondary Education Act?
Well, a couple of things. First of all, the schools that I'm talking about are unlikely to report their placement graduation statistics accurately either. So they're not so concerned about that. And that's what I'm saying. If they're a reasonable, responsible school, of course you're doing that. It makes perfect sense. But the ones I'm talking about are not in that category. And as far as the regulation, I think that the Bureau is well within its bailiwick to set up regulations about what disclosures are needed. Now, I don't know without looking whether there might need to be some statutory change, or whether there is sufficient authority for them to do it on a regulatory basis. But it's like everything. I mean, we're not all going to go out and commit murder, but the murder statute applies to all of us anyway. And the same thing here. Responsible schools are not going to be doing that kind of thing. They're going to have a process, and if they hear Joseph's suggestions, they're going to say, hey, that's a good process, I want to do it. But we have to govern for the ones that are not in that category. In the interim, I mean, I think one possibility, and I don't know, again, whether the Bureau should be doing this or not, or this might be considered an underground regulation, but I just wonder if the Bureau couldn't, build on Joseph's suggestions and put out kind of an advisory here. The law has changed in this way. We know you don't want to be putting people in a situation where they are bound to fail. Here's some suggestions. Now, I don't know if that's legally the Bureau would want to be doing that or not, but I do think that we should at least look at regulatory statutory changes that might be useful in this area.
These are a bunch of great questions that we'll definitely take a look. We'll take back and look to see what is possible. Do committee members have a sense of what you would want to see the Bureau putting into regulations, and that would help us figure out whether it's something we could put into regulations?
As an example, based on what Joseph was saying, this is Margaret. Example, among the disclosures of one or the provisions, I think there's some language in some of the regulation or statute about internships, which is an example he gave here, that for internships, if the placement requires a background check, that the school should do a background check and advise the person, no, we're not going to be able to place you, and therefore we're going to cancel the enrollment because it would be a waste of your money, in essence. And so some requirement along those lines is what I'm thinking. And I don't know, you'd have to, I don't know the specific language. You'd have to think about what exactly you can do and can't do. You don't want to go run afoul of SB 118 either. So, but the whole point about doing it, after enrollment, but soon enough that the student could be protected from owing a whole bunch of money if they're not going to be able to qualify for a placement.
Student disclosures are so lengthy as it is. I hesitate to suggest, but probably the clearest way would be to there are several sections in the SCA that are required language regarding like the refund terms, for example, and so there could be a relatively simple addition to that speaks to this issue. A 2 or 3 sentence clear disclosure that would be required as a component of the SCA. Other schools, as I mentioned, and ours are having conversations around that, because to try to elevate the topic into the top of mind and not just, I think, Margaret, as you said, being buried in the sort of the mortgage paperwork, if you will, you know, the 30-page contract. There is always that risk of information overload at that stage, but that is a tool that the Bureau would have, is to add that language to the SEA.
Another way to go about it would be to just have a provision, and this would have to be statutory, that if any person is enrolled in a program for which either placement in a required externship or in employment is substantially likely, or some language that's maybe not 100%, but you know, really quite likely to fail because of a person's criminal background, that the student is entitled to full refund if in fact they are enrolled anyway, or something like that. And that's one way to do it. So it's not the, you know, you want to push the disclosures, but as we're saying, you know, they're not necessarily going to see the disclosure, but something so that if the school doesn't do the background check, like you were talking about, and they know they've got a program where they won't be able to place the student in a required externship, then they should be collecting money for that enrollment.
I think that kind of goes back to what prompted this whole conversation at the previous meeting, because there is language in the rule about not enrolling students who do not have the ability to benefit from the training, which is why institutions up till now had always done this whole background check process, because they wanted to avoid students enrolling in a program that they potentially could not benefit from. So, you know, that already exists, and I think schools were trying to balance that against this new statute to make sure that students were, you know, still understood what the risks were. So yeah, that one's a bit of a pickle, but I also think there's a difference between an institution telling a student, we're not allowed to ask you this, but we can tell you that this could be a potential problem for you. And if the student's like, all right, I'm just not going to say anything, and then I'm going to wait until I get to my clinical rotation, and then when they do a background check for the clinical site, it turns out the student has a conviction, the institution was, you know, is really not under an obligation to do a background check, and in fact is not supposed to ask as part of the admissions process. So it does create some challenges, you know, where the line is. Do you require background checks? Do you require a school to do background checks? Because not all schools do. A lot of them wait until the student gets to clinical, but they would have disclosed it up front. So Margaret, it sounds like what you're suggesting is if a student is going into a licensure program that could require a background check, that the school would be obligated to do a background check before the student could proceed, which I think is maybe not what was like that wasn't necessarily the intent, but you know, I mean, I think that that's a bigger question about what's the obligation of the student to come forward and say, you've told me all this information and I'm just going to not say anything, or I'm going to make an informed decision and I'm going to enroll anyway. Like, is the school supposed to say, we forbid you from enrolling, even though you're telling us you're okay either way, you know? So that is a tough one.
I think I'm picking up on Joseph's third step. So it's well after they've enrolled. They've gone through orientation, but before, right at the initial of the program, if you have a requirement that the student is entitled to a full refund if they are precluded from, you know, the placement or employment because of a criminal background, you don't require the school to do a criminal background check, but responsible schools like Joseph's do, and others would take the risk if they don't. I mean, that may be one way to go about it. But I'm not talking about, I'm talking about as he has figured out how to do it so that you're giving them the disclosure up front. I just don't trust that those other schools we're talking about are going to give those disclosures in a meaningful way. So what is the step in his process that would protect students and not run afoul of SB 118? It would be step 3, where what he's doing is doing the background checks and saying, no, we won't take you in this program. But, you know, you could set it up so it says, you know, if because of criminal background, you would that they had a record they had before they enrolled, they would not be eligible, then they get a full refund, and then it's up to the school to do the background check or take their chances.
Two thoughts real quick. First, appreciate the vote of confidence that what we're doing is going to work well, but we're in the first inning. Like, so let's talk again in a couple of years, because we need some real data to prove that out. The other point, this is a practical or tactical matter, but we do have students who clear background check at the onset of the program. This is even pre SB 118, where we did it as a condition of admission, and then by the time they reach a clinical later in their program, they now have a conviction and can't. And I would certainly vehemently argue against financial liability for the school in that instance, that has done its diligence, and we can't be responsible, obviously, for every behavior of our students, particularly legal behavior, right? And so
I agree.
yeah.
I agree. That's what I was saying, if they have it before they enroll.
All right, well, I think unless anybody else has any comments or thoughts on Senate Bill 118. Thank you, Joseph, for sharing your journey. We'll see where the destination ends up being. As you said, get some data under your belt on how this works. And I'm sure that any institution that's listening right now, I think there's a lot of schools that are trying to figure out how to make this work in the best possible way. So this is super helpful. Thank you for sharing. Unless anybody has anything else, speak now. Okay, then we can open up for public comment on agenda item 9.
All right, this is the moderator, and I've opened up the Q&A panel. If any member of the public would like to make a comment, please type. I would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions, and we'll give you a moment. All right, I see no requests for.
You kind of cut out there, Trish, but I think you said there was no questions. And so
That is correct. Sorry about that. Yes. So
that's
shall
right.
I close?
Yes, please.
Okay.
Close it out.
It's closed.
All right. So that brings us to agenda item 10, which is the future meeting dates. The meeting dates in the packet, February 16th, May 17th, August 18th, and November 16th. I don't know if anyone has had a chance to compare those against their calendar to determine if those are conflicting with anything. Does anyone have any thoughts or comments about the dates?
February 16th is my wedding anniversary, my 30th wedding anniversary, actually. So I can do the meeting as long as it's in the AM. I think we'll be okay.
We'll get you out as early as possible. Will that work?
Yes.
Well, and I will remind everyone that per Carrie Holmes's comments earlier, the allowance to hold meetings virtually currently goes through the end of January. So right now, the presumption is that these meetings would all be held in person in Sacramento. So I'm not sure if that changes the equation. Apparently I don't have a very good track record. You might have noticed on keeping these meetings short. So, but we might be able to look at other dates that week, Joseph, if that would be preferable.
I'm sure his wife would appreciate it.
I was actually being facetious. It's the middle of the week, and so that specific date isn't critical.
Okay.
All right. Well, so for now, we'll assume that the dates as presented work for everybody, and obviously, if anything comes up, we have addressed changes in the past. We'll figure it out. So, all right. Do I need to do public comment on meeting dates? I suppose it's an agenda item, so I will ask the moderator to open the floor.
All right, I am opening up the Q&A panel, and if any member of the public would like to comment on this agenda item, please type that you would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, thank you.
You're welcome.
All right. So that takes us to item 11, which is future agenda items. Lynn and Deb are without a quorum. What do we do with this? What do we do with this item? Are we allowed to have people make recommendations for the full committee to consider at the next meeting? Because in that case, you might as well just wait till the next meeting.
I will say, I think we actually do, we've had some internal conversation. I think we actually do have a quorum at this point.
Oh, great.
I believe we have 6 voting members. Hearing no one correcting me, I'm going to assume that is accurate.
Well, all right. Does anybody have anything that they would like to suggest as a future agenda item?
Sure. This is Margaret, and I don't think it would be a problem even if we didn't have a quorum, because all we're doing is we're discussing, not taking any action, and we're not even voting for a recommendation, but the Bureau can hear what we say and they make a decision what they want to put on the agenda, is the way it's worked in the past. So I think we're good regardless, but I'd like to suggest a few things. One is seeing how the STRIF could be so impacted by one big school that doesn't get federal loans. I think that it would be good to have a discussion about whether the current statutory cap and statutory point at which we can again begin charging for STRIF should be reexamined in light of this one major hit. I mean, maybe it's a one-off, but I think we maybe ought to take a second look at that. And we've always been under the impression that it was well more than we would ever need, but now, I think we need to take a second look at that. Is we had talked a little bit last year, and maybe it would be a good time to raise it again, whether we would like to consider taking a vote of the committee to recommend that the legislature provide some general fund money for some portion of the Bureau's operations. Another thing is, I would, and I don't know, I mean, I know you're trying to do all kinds of things there, but I think it would be helpful if you could, and maybe not at this meeting, at the following one, choose some school that had closed within the last year and do an after action assessment about what things weren't done, could have been done, should have been done, that might have made a difference. And give us a report on that. And again, if that can't be done for February, sometime in this upcoming year. And the other topic is, when we first had the statute, I think the regulations about how a school could continue operating after applying, if they applied in a timely fashion. I think at that point, the Bureau was way behind in approving applications, and it didn't seem fair that schools should be dinged just because the Bureau wasn't getting things done very quickly. But now that the Bureau is more caught up, I'm wondering if we shouldn't take a look at that and consider whether there needs to be some changes in that, in the circumstance in which, for example, the Bureau received the application, notified the school it was incomplete, and then there should be a time limit after that notice. Or they said, no, these things need to be changed, and there's some time limit after that. So schools can't go on operating for 2-3 years, not having had that renewal or whatever it was actually granted, because the students are still there. And then the final thing I would kind of like to raise as a topic is one that people may not want to discuss, but we have had experience with this agency in its various incarnations of being decimated, ended, and reestablished at least 2 different times in the last 20-30 years. And each time that happens, either we lose staff, we lose institutional memory, we spend a lot of time coming up with new regulations, interpreting the new statute. And so I would like to have a discussion about whether we could recommend to the legislature that they continue to have legislative reviews on the schedule that they deem appropriate, that there not be a sunset. That if I can't foresee a time when the schools or the student advocates wouldn't want this agency to continue. And if they want it in a different form, then the legislature can vote to do something different with it. But having it so that if it doesn't get the votes, if it doesn't get the governor's signature, the agency ends, I think has been twice disastrous. And would recommend, and I suppose it has snowball's chance in hell of getting anywhere, because that's kind of the legislature's procedure with all these boards and bureaus, but it just strikes me that it is something that we might want to weigh in on. And that's it.
Thanks, Margaret. Anyone else? I would just like to make the ISA topic another, just as an update. We'll see what gets accomplished between now and February, but I would like to kind of keep that conversation open as well. All right. Well, hearing no other requests or suggestions, I suppose we can open the floor to public comment on future agenda items.
All right, I've opened up the Q&A panel, and if any member of the public would like to comment on future agenda items, please type that you would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions, and we have a Robert Johnson that would like to make a comment. So Robert, I'll let you know when you can unmute yourself. Okay, Robert, you should be able to unmute yourself, and you'll have 3 minutes.
Thank you. Robert Johnson, California Association of Private Post-Secondary Schools. Fundamental to looking at the Bureau in the next reauthorization, which actually I'm kind of surprised to hear Margaret say that she doesn't like those, because essentially there's always opportunities to kind of keep more requirements on schools pretty much in every reauthorization. So we see that over and over again. So real surprised by that comment. Two things need to be established to look at the Bureau correctly. One is the Bureau keeps saying there's 1,000 and some mains and 600 branches, but nobody has ever defined any of those mains and branches by actual ownership. And so the implicit assumption by the Bureau is that there's 1,000 institutional owners in California that they're regulating, but the truth of the matter is that a number of those institutions, particularly campuses and branches, are owned by the same group of people. So until the Bureau defines ownership of the individual campuses and bureau and branches, we really don't know how many people are running schools in California. And that seems to be a real basic requirement for any kind of compliance scheme. The second part that needs to be essentially looked at is the actual number of students who are enrolled in the sector. You make a huge point of going through numbers of complaints, but you never contrast it against what percentage of the population are we talking about. So the legislature sees a number, but doesn't realize, is that 1%? Is that 2%? Is that 5% of the school population? The Bureau has declined to essentially define how many students are enrolled in the sector at any one time. And the question then begs itself, how can you basically decide on a regulatory scheme for a sector if you don't know how many ownership companies exist or how many students are actually enrolled in the school? It seems basic common sense to basically find those numbers and integrate those into your discussions in terms of policy. And until you do that, it's just kind of waving at the fly in the wall. You really don't know what you're doing. So just for future thought, you may want to consider that. Thank you.
All right, and that is the last of requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
All right. I think that concludes our business for today. Is there anything else for the good of the order before we adjourn? All right. So as we said, our next meeting is scheduled for February 16th, 2022. As of now, in person, but we'll see what happens between now and then. And I hope everybody has wonderful holidays and safe and healthy and happy, and we'll be speaking to everybody soon. And thank you to the Bureau, the staff, and everybody that put together their great presentations today, and to the people who joined us who normally aren't here. Appreciate them doing so as well. Deb, did you have anything you wanted to add before we say goodbye?
No, just thank you all for the thoughtful discussion.
Excellent. All right. Take care, everyone. We'll see you in February.
Thanks, Kate. Thanks, everybody.
Thanks, Margaret. Bye.